Yeah, but you get to be on camera. Which one's your pretty side? Oh, that's right, you were. We're going to start our they're right downstairs. Yeah. Yeah, we can't be disturbed. Yes.
Yeah. We got the transcript.
The judge is coming out. All rise. Superior Court is now in session. The Honorable Susan Circle presiding.
Thank you. Please be seated. Good morning.
Good morning, Your Honor. John Sheeran for the State of Washington. This is State versus Jonathan D. Harris, cause number 15-1-02431-2. Defendant is present in court, in custody, representing himself. This comes on before, Your Honor, on defendant's motion to withdraw his guilty plea. Given that it's the defendant's motion, let the defendant proceed.
Before I give you the floor, Mr. Harris, my understanding is that this is being streamed live. If anyone has an objection to that, if you could let me know, please, now. All right. Hearing nothing, I'll assume that's okay. I apologize for the delay in getting started. I just was given the response of the state to the motion for relief from judgment. So I've had a chance to read that. I assume Mr. Harris was given a copy of that as well.
Yes, he was, Your Honor. I apologize for getting that to you this morning, but the hearing wasn't set until Monday.
So. Now, finally, before I hear a legal analysis on the motion to withdraw a guilty plea, I know there was some suggestion the other day that there might need to be some evidence taken. Is that something we need to address first or not? I half expected there might be a declaration of the attorneys, or declarations plural, and I didn't see any response from the Department of Assigned Counsel.
No, Your Honor, the state has not provided a declaration. I expected that if the court found there to be, on the pleadings themselves, a legal basis to withdraw the plea, that the court would have to be making a credibility determination with respect to Mr. Harris and his attorneys. That being said, if the court has read Mr. Harris's brief and the state's response and finds there isn't a legal basis, that he has not met the standard of manifest injustice, the court can make a ruling on the filings.
Thank you. That was my feeling as well on Monday, but given the lengthy discussion we had on the record on Monday, I thought there might be more to this hearing than a simple legal argument. Maybe not so simple. Mr. Harris, this is your motion.
Yes, Your Honor. Bring forward a motion to dismiss or withdraw my guilty plea. It's excuse me, I'm a little stuffed here. Where is it? On 27th, I was charged with murder in second degree, and I filed a motion to withdraw my guilty plea on facts that I was lied to. made promises that did not come, that were wrong. Was misled into believing that I could take a plea, to withdraw, to appeal my case when I went to prison, and that I was just lied to. And if you see for your case rules that for an attorney being lied to is Garcia versus U.S. 278 F.3D 134, 2D Circuit 2002. There's also evidence that while being in custody here of 8 months, I never had a discovery to look at or research on, and I had hired some investigators to uncover 5 pieces of evidence that I was not aware of, which is there's never had Miranda rights.
Your Honor, if I may, it would appear that Mr. Harris is making factual assertions at this point, and it would, in the state's position, would be that it would be appropriate for him to be sworn, and if he wants to testify, so be it, and then be subject to cross-examination.
Mr. Harris,
Your Honor.
do you want to raise your right hand and be sworn?
Sure.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Go ahead.
The evidence that was uncovered, and Mr. Quigley, at the time when he was my lawyer, was lying and misleading me. My investigators found 9.1, and this is on the withdrawal plea. You may have a copy of it.
Are you reading from page 2?
It's page 3 of 4, and it is line 6 through line 16. It says there is no record the defendant signed any Miranda waiver before making statement to police. 9.2. There is explanatory evidence that prosecutor has concealed in form of a bloody t-shirt that allegedly belonged to the victim. The defendant has constitutional right to have an independent lab and test a t-shirt to see if blood is the victim's. 9.3. The defendant has a constitutional right to interview the bartender, the neighbor, and the store attendant. With those, I have made concerns of to cross-examine them, and I got a no action on that. 9.4. The defendant was now received evidence that the video from the bar was misleading and incorrect. 9.5. Me, the defendant, I received evidence from that there is no TCI reports from Washington State Patrol. And in my discovery as reading, there is none.
What does that acronym stand for?
TCI?
Yes.
It is Tacoma crime? No. I'm sorry, ma'am, I don't know.
Okay. Anything else?
And then actually 18 through 9, it says 9.6, based on all the lies and cover-ups in this case, at the time under State versus Taylor, 83 WN 2nd .594, I, the defendant, would like to withdraw my plea of guilty. That's all I have, Your Honor.
Mr. Sharon, do you have any questions?
Yes, Your Honor. Mr. Harris, you read and write? You read and write?
A little bit, yeah.
Who's Leslie Gagney?
It's Nagy.
Nagy?
It's my mother.
It's important to be truthful with the judge.
Yes, sir.
You're not a liar,
No,
and you stand up and tell the truth.
sure do.
And you stand up and tell the truth even when it's uncomfortable.
Yeah, I try. It's very hard to stand and talk in front of people, but I always tell the truth.
You don't like it when other people lie.
Nope.
Who is Nicole?
Who's Nicole?
Who's Nicole White?
Nicole White was a friend of mine.
Describe her.
Small, happy, outgoing, hunter, fisher, amazing at pool, good all-around person.
You liked her.
She's cool. She's a good person.
You're moving to withdraw your guilty plea because you didn't commit the crime?
Didn't commit what they're telling me I did, which they're charging me for.
In your letter to Judge Culpepper, you said you were innocent of this crime.
Yes, sir.
In the bar complaint that you filed against Mr. Quigley, you said, I pled guilty to a charge I did not do. Is that correct?
Yes, sir.
On the 27th of July, you came to court to enter your guilty plea?
Sure, I did.
Over the past 15 months, you've come to court repeatedly.
I have.
So you've been to court on this case before,
I have.
and you've pled guilty on other cases.
Other cases as for be clarified.
In 2008, you pled guilty to 2 counts of assault in the second degree?
I took a Alfred plea saying that I was not sure that I was going to win the case. So I took an Alfred plea saying that there was no way I was going to win, but I was going to do time no matter what.
So in 2008, you pled guilty to 2 counts of assault in the second degree.
Yes, sir, I did.
And there are several misdemeanors that you've pled guilty to as well.
Yes.
And in each of those cases, you waived the same rights that you waived in this case.
Yes, I had a lawyer that was working for me, not against me.
In each of those cases, you waived those same rights that you waived in this case when you pled guilty. Is that correct?
Yes, sir.
So, when you pled guilty in this case, you're saying you were not honest with the court.
When I was brought to court on that date, July 28th, or I believe July 28th, or July 28th, that day I did not receive medication that I was taking in the morning of this, which helps me function. Previous to that altercation, I was down in the lower courtrooms, same as I am now, handcuffs and belly chains, sitting in a tiny room for 5 hours, sitting there wondering, what am I doing in this little room? Someone said I didn't have court in the morning. So I sat down there all day long till they said I had court in the afternoon. With not getting any medication, sitting there.
Going to court that day and pleading guilty was something that you planned on doing and had discussed with your attorneys for months before this?
No.
No?
No, they have only come to see me a whopping 5 times since I've been here in 16 months.
And so you never expressed a desire to plead guilty and avoid trial?
No, not to a crime that they allegedly said I committed.
So, you From what I understand, you pled guilty because Mr. Quigley threatened your life.
Yes.
So when you walked into court and pled guilty saying you intentionally killed Nicole, that was a lie.
Yes.
And that was a lie that you told because it would benefit you at that time because you thought that Mr. Quigley would have you sent to prison for the rest of your life.
The guys who, or the people who have wrote the statement of,
It's a simple question. You lied to the court because you thought it would benefit you. You would get less time than if you had gone to trial.
no.
You lied to the court.
I was misled to what Mr. Quigley was offering me.
You read the statement of defendant on plea of guilty?
Where's that at? It's kind of hard. Can you repeat what you just said, please?
You read the statement of defendant on plea of guilty.
No, I didn't.
You signed the statement of defendant on plea of guilty. Is that correct?
I have no knowledge of that.
You have no memory of appearing before the court and entering the plea of guilty?
I have memory of that day, yes.
And you don't remember signing the statement of defendant on plea of guilty?
I do not.
Do you remember a separate plea agreement?
Where is it? Oh, here it is.
Do you remember a separate plea agreement, Mr. Harris?
Sure.
Because I'm not sure you have a copy of it in front of you,
I don't.
hand you what's been marked as Plaintiff's Exhibit 1 for the purposes of this hearing.
Plea agreement. See,
Does that look familiar?
no, reason this does not look familiar, because when I left court that day, I have not received a copy of it.
You're aware that you signed it?
Actual plea. Said agree. I looked at that. Yes, sir, I did sign it.
And on page 2, line 17,
Page 2, line 17.
could you read into the record what you signed?
It says the defendant will plead guilty to murder in the second degree as charged count 1 of the Second Amendment information, because the defendant is in fact guilty of charged offense. The defendant stipulates that the facts and statements, including in plaintiff's declaration for determination of probable cause, are true and accurate, and such facts and statements from a factual based finding the defendant guilty of murder in second degree death, Nicole White, beyond reasonable doubt.
And was that true?
No,
So you lied to the court that day when you signed that.
I did.
Could you turn to page 3? And line 8, what is that, what's the title above that
It
paragraph?
says waiver of appeal.
Could you
The
read
defendant
that?
understands that he has the right to appeal this conversation. The defendant understands that since he has entered pleas of guilty to the change of the Second Amendment information, he has waived his rights to raise internal issues as discussed in the statement of defense and plea of guilty. In an appeal, the defendant understands that he has a right to appeal any sentence that is outside of his standard sentencing range. The defendant hereby waives all any and all I don't know what that word is. Appeal rights pertaining to conviction and sentence of passive plea agreement in accordance of State versus Lee 132 Washington 2D 498, 505-506, 1997.
Could you take a look at page 4? And read lines 2 through 5.
Through 5. This defendant stipulates that he is completely satisfied with representation afforded by his attorney and that his attorney have rendered efforts assistant in their representation of him in this matter. And that fact is not true.
So you lied to the court when you said that?
Sure did. I didn't even write that.
Could you take a look at page 5? And read lines 5 through 9.
The defendant understands the full fulfillment of his obligations under the plea agreement, including providing full, complete, and truthful response to detectives of Pierce County Sheriff's Department regarding any and all aspects of the crime to which he is pleading guilty in this case. The defendant understands that his attorneys may be present for these interviews. The defendant understands that the deputy prosecutor attorney may be present for these interviews. The defendant understands these interviews will be audio recorded.
Was it your understanding that you would meet with the Sheriff's Department and explain to them exactly what happened and how Nicole White died?
I would.
Was it your understanding that you would do that at that time?
Yes. But on this fact here, I received in the mail a important book, law book.
So,
Excuse me.
I apologize, Joe.
A law book to understand my rights in my case of a conviction and the constitutional rights I have in this place. As having an attorney is supposed to tell you exactly what goes on in court and what your constitutional rights are. When I signed this and talked about this, I didn't even know what my constitutional rights were before or after this was. I didn't know what they were until I got this book and I started to read it. With not knowing that, that's a pretty big reason to withdraw a plea of guilty for a crime that I didn't commit, or if I didn't understand stuff. Now you have to be truthful and honest.
Objection, non-responsive, Your Honor.
Sustained.
Mr. Harris, at that same plea hearing, the court went over your statement of defendant on plea of guilty with you. Do you recall that?
No.
You don't recall the court asking you that you had a right to remain silent, but you're giving it up now by going through this process with me and answering my question?
Oh, yeah, I remember that.
You remember that?
Yes.
You remember what your answer was to that question?
Yes. Yes, ma'am.
And the judge asked you, do you wish to proceed?
I said yes.
And the judge said, so I'm going to go through a document with you, the statement of defendant on plea of guilty. And my first question is, did you have a chance to go through this and read it yourself?
No.
And your answer to the court was, yes, ma'am. Do you recall that?
Yes.
So did you lie to the court when you said that?
Yes, because I...
Court then asked you, did you also go through it carefully with counsel, Mr. Quigley and Mr. Katayama? And your answer was, yes, ma'am, I did. Do you recall that?
Yes.
The court asked you if you understood everything, and your response was, yes, I did. Do you recall that?
No.
You don't recall saying that, or you don't recall it happening, or?
I recall it happening, I just...
And the court asked you, were they, referring to Mr. Quigley and Mr. Katayama, were they able to answer all of your questions?
No, they weren't.
And your response to the court, however, was, yes, they were very helpful. So you lied to the court when you said that?
What page is that? Did you have that on?
That would be,
Page 14.
and I don't believe, he may not have a copy of it.
You want to use the original?
If you could.
I'll take the tabs off of it. Given that you're using this, Mr. Sharon, it's not been filed yet, but I think this is the original. I think it should be filed.
Probably appropriate. And I'll hand you what will later be marked as Exhibit 2, or just as labeled as the transcript from the plea hearing.
I think it's page 14.
Thank you, Your Honor. I believe we were at line 10, where the court asked you, were they able to answer all of your questions? And you responded, yes, they were very helpful.
I said yes, but I never said they were very helpful.
So you're saying that the court reporter got that wrong?
Yes, sir.
The court asked you, was there anything that they were not able to answer, or any confusion or questions that you have for the court? And you said, no, ma'am?
That's correct.
The court then goes through the charged crimes of murder in the second degree, and assault in the second degree, and assault in the third degree, and asks you on line 21, did you go through the elements of those three crimes very carefully? And what did you tell the court?
I said yes, ma'am.
And did you understand them, the court asked? What did you say?
I said yes, ma'am, but I did not say I did. I just said yes, ma'am.
So what you're saying...
I only said a few chose words when I appeared that day.
The court asked you a very specific question. Did you understand them? You said, yes, ma'am, I did. Is
I
that
said
correct?
yes, ma'am.
You didn't say I did.
No, I did not.
So the court reporter got that wrong.
Yes.
But you answered the question in the affirmative.
I just said yes, ma'am.
The court asked you if you had any questions about the elements. What did you say?
No, ma'am. The reason I said no, ma'am, is because I have an issue with talking in front of people. I get nervous and scared.
So having previously pled guilty on several cases, all of a sudden you couldn't answer questions honestly with this court?
With my other cases, sir, there wasn't a lot of cameras and people in there.
Cameras don't make you lie, do they, Mr. Harris?
No, but they make you nervous. And when you're being lied to your whole entire time of being here, you don't know what's truthful anymore.
The court asked you if you had read the constitutional rights that were listed on the top of the page, second page. Do you recall going through those rights with the court?
Second page?
No, I'm sorry. On the second page of the statement of defendant on plea of guilty, there's a list of rights you're waiving. Do you recall that?
Your constitutional rights listed, did you have a chance to go through? You mean line 5 and 6, or no, 4 through 6?
Yes.
I did not.
Court asked you, do you understand pleading guilty today you're giving up all of these constitutional rights?
I said yes.
And the court asked if those were your initials in the margin.
Yeah, they were.
And they were, weren't they?
Yes, sir.
They were because your attorneys had gone over that document with you.
They told me where to sign, and I signed it. I didn't read it.
They didn't go over the statement of defendant on plea of guilty with you.
No, sir.
Your attorneys told you that the plea agreement that you reached with the state was the best you were going to get. Is that correct?
But it was the best I was going to get?
Yes.
They said that was the best I was going to get because...
No, I didn't ask it because. I think I'm just asking you if they asked, if they told you this was the best plea agreement you were going to be able to reach with the state.
They said this was the best because of unscrupulous evidence they were going to give me life. This was the best one I was going to get.
And they told you about aggravating factors if you'd gone to trial that might have increased your sentence.
Yes.
They discussed with you deliberate cruelty and particular vulnerability.
They said those words, but they didn't explain them in detail at all.
They told you if you're convicted at trial with these aggravators, you could be sent to prison for so long you'd never get out.
Yes.
You assert they misled you with respect to the strength of the state's case, but you've never evaluated another case before, have you?
No.
They gave you their honest assessment of the case?
They gave me words with no paper to back up what they said. I have just received my discovery to everything that I have received, statements, this and that. I finally got to read them last night. And all this time I've been here, every time I've left court, to have the piece of paper saying, oh, this is when your next court date. I received it all yesterday. Which is pretty hard to fight a case or even work on a case when you have nothing to go on.
Last night you did an interview with Cairo TV.
I did.
You said you didn't know who killed Nicole.
I said I didn't know to a certain question.
That certain question was, did you kill Nicole, wasn't it?
I said no, I didn't.
You said no, you didn't kill Nicole?
No.
Okay. You said you got to look out for your family?
Yeah, I look out for my family.
You said that the defense attorney threatened you? You told Cairo TV that?
Yes.
You said that you were misled by your attorney?
Yes.
You said that you pled guilty because your attorney used scare tactics.
Yes.
And then you said, I know I have to do the time, no one gets out, no one gets to go free in this. Is that correct?
True.
But you told them that you didn't kill Nicole. Is that
That
correct?
statement that I said refers to everybody in this courtroom. Nobody goes free in life.
So when somebody asks you a specific question about killing somebody and your response is, I know I got to do time on this, you don't think that's an admission that you were responsible for the death of Nicole?
No, I don't.
Okay.
Because I'm in jail doing time for a charge that you gave me, murder in second degree, assault in the second degree, and third degree assault.
On July 31st, 2016, you were in jail?
2016?
Yes.
Yeah.
You called Leslie Nagy,
Yeah.
and she's your mother?
Sir.
You spoke to her more than once that day?
I think so.
You told her you shouldn't have pled guilty because you could have gotten manslaughter?
Yes.
It said the state couldn't prove premeditation?
No.
No, you didn't say that, or no, that's your belief that the state couldn't prove premeditation?
I believe they cannot prove premeditation.
So the question was, you told your mother that the state couldn't prove premeditation?
Yes.
You said the only reason you pleaded guilty was because, quote, you guys wanted me to do it.
Yeah.
So the only reason you pled guilty was because your family wanted you to plead guilty?
Yes. Mr. Quigley, on the record, Mr. Quigley called my mother and told her that if you could get your son to agree to these charges that we're bringing, that this would be better for him than to go to trial.
You told your mother, I know I have to serve time, Mom, I know this.
Yeah, I'm doing time right now, ain't I?
You said, Mom, I'm going to try to get manslaughter where I only do 12 years?
Yeah, close to that. 15, 12, 20.
Your mother said, well, I'm sure that's all you're doing is thinking, you're trying to think of a way out of this, and I don't think there is one, but then you told your mother, I'm not thinking of a way out of it, I'm thinking of a way to do time, but at time. Mom, I didn't intend for any of this. I didn't intend for her to die. I was thinking recklessly when this shit happened. All these key words, Mom. There was no intent, and I did not intend to kill her. So how can they charge me with intent and then he wants me to plead guilty?
That's hearsay.
It's something you said, isn't it?
Yeah, it's hearsay though.
If the court can just rule on the defendant's objection, then you're on.
Objection for hearsay.
Overruled.
Thank you. You had a second phone call with your mother that day?
Sure did. Yeah.
At that point, you were talking about manslaughter, and you told your mother, Mom, all these people that I'm seeing are the same cases as mine, same cases, and they're getting manslaughter. What's the difference between theirs and mine? It's nothing. There's all the same shit. The only thing that's different is they used guns or a knife, and I used a blunt object. Is that what you told your mother?
Did. In the evidence that I read yesterday, the autopsy report,
Objection unresponsive.
Sustained?
And then you're talking more with your mother about this. And you said, yeah, and being drunk is reckless, which is, wasn't thinking. I wasn't thinking when I struck the victim. You tell your mother that?
no,
You didn't tell your mother that?
no.
Talking to your mother, and you said, She said, the fact that you hit her, and I don't know where you hit her the first time, you know, in the head, face, I'm assuming in the head, because I don't know if she hit something, but it's a fact that you continued on with many blows to the body, is where the difference lies though, okay? I'm not just giving you facts. I'm just giving you the facts. I'm not saying anything that's all that is, okay? The facts. Yeah. Your response was yeah. And then your mother said, and I don't know if you even remember doing that or not doing that, or what made you lose it in the first place. Do you know what I'm saying? And you responded, something triggered me from, and then something unintelligible. And you said, I think something she said or something, I don't know, stuff like that. Maybe I got triggered by something, I don't know. Maybe something triggered me like. And she said, but you said she swung at you or something. Yeah, we were arguing and she swung at me first, and I don't like being hit for one. You remember telling your mother that?
No, I do not.
Do you doubt that you told your mother that?
No, Honor, I did not. Or no.
In the allocution, the plea agreement, there was an allocution statement in there that we talked about a minute ago with respect to you sitting down with the sheriff's deputies and telling them exactly what happened.
Yeah.
And that was largely in part to a promise to Nicole's family that you would tell them what happened, that you would explain to them how their daughter died.
Yeah.
And you told your mother you needed to do time. Is that right?
Yeah.
And you told her that you were reckless. Is that right?
Yes, sir.
And you told her that you hit Nicole and something triggered you.
Yes, sir.
What triggered you?
Being drunk at the time, we both were drinking, had a good day, good night.
Good day, good night, and all of a sudden you started beating on her?
When you're drinking, I have recollection of what was going on when that happened.
Well, why don't you walk us through what you do remember?
Objection? I just...
Do you remember being at the bar?
I do, kind of. I remember the first half of the bar,
And you remember going home?
vaguely.
You remember taking Nicole to your house?
I didn't, she drove me to my house.
You remember getting in an argument with her?
Some parts.
Do you remember telling several people that you remember getting into an argument with her?
No.
You don't remember telling your mother that?
I vaguely remember some stuff.
Do you remember hitting Nicole?
I remember arguing with her.
Do you remember hitting Nicole?
I remember pushing her.
Do you remember hitting her?
No.
How many times do you think you hit her?
I have no idea.
What'd you do with her body?
I have no idea.
You have no idea what you did with her
No,
body?
sir, I do not know what I did with her body.
You don't recall dumping her body?
No, sir, I do not.
You don't recall wrapping it up before you put it in the car?
No, sir.
So you have no way of knowing whether or not actually that you actually did intentionally kill her?
No, sir, I do not.
So you may have intended to kill her?
No. When we were...
You were obviously mad enough at her to kill her, right?
No. I was not mad at her.
You weren't mad at her?
We were arguing. We were just...
You beat the woman to death and you're telling this court that you were not mad at her?
Say that again.
You beat the woman to death, and you're telling this court that you were not mad at her.
No, sir, it wasn't. But we had an argument, got it at hand, and I did not beat her to death.
You read the Declaration for Determination of Probable Cause?
I have not.
When you were arraigned, you were provided a copy of it?
I was not.
You weren't provided a copy at arraignment?
No, I wasn't, sir.
Declaration of Probable Cause. So you have no idea how Nicole died?
No. I just got, like I told you earlier, that I just got
Objection,
every
non-responsive.
piece
Sustained.
of paper. Just got every piece
You've answered the question.
Huh?
You've answered the question.
Oh, okay.
Defense counsel never went over with you the extensive injuries that Nicole suffered?
I believe so.
So you know that she was beaten to death?
He told me that she had multiple injuries. And that she wasn't beaten to death, she was, I don't know the words of it.
You've said defense counsel, and I believe you were referring specifically to Mr. Quigley, threatened your life.
Yes.
When you say they threatened your life, I believe you told Cairo last night that he did not threaten to kill you, but he threatened that you would spend the rest of your life in prison.
That's pretty much killing you.
So Mr. Quigley did not threaten. Mr. Quigley did not threaten your life. He threatened. He gave you legal advice.
Well,
He told you his legal opinion as to what would happen if you went to trial.
the way he said it to me was of a threat. Now, like you're talking to me, that's legal advice. The way he spoke to me was not legal advice.
So you took his legal opinion as a threat on your life.
I did.
So he didn't threaten to kill you or hurt you.
He told me he had overwhelming evidence to the crime that I did not. Crime that I pled guilty. No, that's Mr. Quigley. The prosecutor had overwhelming evidence that I did the crime, and that if I did not plead, I would spend the rest of my life in prison. Those were his words.
So that advice scared you into pleading guilty.
Yes.
What you really got here is buyer's remorse.
What's that supposed to mean?
You really just wish you hadn't done what you did because you're going to do too much time.
No.
There are certain pieces of evidence you believe should have been tested or people that should have been interviewed,
Yeah.
and in your review. You were aware when you pled guilty that you would be waiving your right to do those things. The plea statement specifically addresses that you're waiving your right to call witnesses. Is that correct?
I do not remember. I do not recall that.
No other questions, sir?
Anything else you would like to say, Mr. Harris?
No, Your Honor.
Mr. Sheeran, would you retrieve the original transcript, please, so that that can be marked and be part of this record? Is there anything else from the state?
Your Honor, it's defendant's motion, so I'll leave that for...
I'm just asking if there's anything else that you wish to
No other
present.
questions for Mr. Harris at this time?
Mr. Harris, now is your opportunity to make legal argument on whether or not your motion legally supports a withdrawal of your plea of guilty.
Your Honor, if I may. With it being said, I came here today to withdraw my guilty plea. I'll find it, excuse me. With the motion to withdraw guilty plea on it says page 4, the affidavit to support motion to withdraw guilty plea, line 25 through 28. It says, I, the defendant, claim that manifest injustice occurred in State versus Taylor 83 WN 2D 594 596 521 P 2D 699. The specific claim the defendant made at this time are under Strickland versus State of Washington 466, which goes to page 2, line 1 through line 5, U.S. 66880 LED2D. The defendant's I, his attorney, forced him to pleading guilty. As defendant, I was misled into thinking that I would be able to appeal my guilty plea. The trial attorney lied to me by telling me that I have direct appeal. That was for a case trial. That was Garcia versus U.S. 278 F3D 134 2D Circuit 2002. I, the defendant, was misled regarding rights to appeal within title of factory of sentence. Line 4, paragraph 4, line 9 through 10, it says, I, the defendant, now to the court, I did not fully understand the consequences of my plea because of Mr. Mark Quigley, that the Pierce County Prosecutor's Office had overwhelming evidence that he did the crime, and that if he did not take the plea, that he would spend the rest of life in prison. Line 15 through 18. Paragraph 5. I, the defendant, did admit to committing the acts as charged. He now makes the following statement to support the argument that he did not commit the acts as charged and that his trial attorney misled him to pleading guilty in the crime that I did not commit. With that being said, there's one more thing. Line 23, paragraph 7. So I, the defendant, can be used to support the charges. The trial attorney roles a misleading Mr. Quigley, C 466 U.S. 66880 LED2D. Also, the patient is not bared by RCW 10.73.909. The defendant has made a substantial showing that he is entitled to relief, or that 2 results in the motion require a factual hearing. Now on it says, page 3 of 4, line 1 through 4, it says, on the 30th, the defendant I hired my own legal investigator and criminal paralegals in the state of Washington, and was uncovered was that for 8 months, my attorney, Mr. Mark Quigley, was lying to me and misleading me. that's where we uncovered 5 things that were hidden from me.
Which you've previously
What I previously
stated
said,
to the court.
stated to the court. This is page 3 of 4, line 18 and 20. This is based on all the lies and cover-ups in the case that at the time under State versus Taylor 83 WN 2nd 594, I, the defendant, would like to withdraw my guilty plea. In line 22 of 24, says I, the defendant, should be permitted to withdraw a guilty plea since there existed only obligations expressing of qualified guilt, plea with a statement of fact. And this is page 4 of 4, line 1 through 3. His, I don't understand, I don't know this word. His quarrels?
I'm sorry?
This word, I'm not good with some of the words.
Where are you reading from?
It's page 4 of 4, line 1. It says
Colloquy?
his, what is it?
Colloquy.
Colloquy. What the court shows that the defendant was in fact declaring his innocence despite his formalistic reactions of guilt. Under these circumstances, he should be allowed to withdraw his plea and interpose a plea of not guilty. That is all I have, Your Honor.
Mr. Sharon?
Thank you, Your Honor. I think there's probably a threshold factual question. If the court's finding the defendant's testimony wholly not credible, the state need not call Mr. Quigley and Mr. Katayama to contest the allegations as witnesses. If the court wishes, the state will not call those witnesses.
The question really is whether or not you think that's necessary, assuming there were an appeal in this case. I guess that's my question for you, Mr. Sharon.
I think it would largely come down to the factual findings that the court makes with respect to Mr. Harris's credibility in this hearing. If the court's finding him not credible, then I don't need somebody to say what he said isn't credible.
Mr. Harris is not credible.
Thank you, Your Honor. With that said, I think that we proceed directly to the legal argument. Mr. Harris has not demonstrated a manifest injustice, in short. He has 2 or 3 primary allegations. The first is that Mr. Quigley threatened his life, is how he put it. Mr. Harris doesn't like the fact that Mr. Quigley gave him straightforward, honest legal advice. If you proceed to trial, you will spend the rest of your life in prison. You may not like Mr. Quigley's demeanor when he says it, but that's Mr. Quigley's analysis of this case. Mr. Quigley's been doing this. That's how long he's been doing this is not in the record. But Mr. Quigley's the assigned defense attorney, and as such, it's important for him to give honest advice to his client. The fact that his client doesn't like it and takes it as a threat is something his client could raise with the court in his plea hearing or any of the other hearings before that. Getting down to the things that he says Mr. Quigley...
This is legal argument.
Getting to the things that he says were discovered after his plea that he learned that he should have known. These are specifically things that he waived at the time of the plea. He waived his right to call witnesses. He waived his right to examine evidence. He waived his right to cross-examine people and to do Washington State Patrol, review Washington State Patrol reports or video from the bar. He waived all that when he pled guilty. This isn't something that he gets to go back on and start all over again. The only other direct issue is whether or not Mr. Harris was informed of his right to appeal his plea. It's in the plea paperwork, it's in the statement of benefit, it's in the separate plea agreement that he signed, and given the court's finding with respect to credibility, I don't think there's any reason to believe that Mr. Harris was unaware of the fact that he could not appeal the determination of guilt with respect to his guilty plea, but that he could appeal a sentence outside the standard range. It's what the court informed him, it's what the counsel informed him, it's what the paperwork informed him. given his history of having pled guilty before, I think he's probably been told that on several occasions. Your Honor, I ask the court to deny the defendant's motion and that there was not a manifest injustice demonstrated.
Thank you. Anything else, Mr. Harris?
No, Your Honor.
I had the benefit of reviewing your motion and all of the attachments. I've had the benefit of going back, frankly, and looking at what is now marked as Plaintiff's Exhibit 2, which is the original transcript. And I went through both those documents a couple of times to reassure myself that I had gone through everything with you at the plea in July. I also looked up the cases that you quoted, two of which were reversed. A withdrawal was allowed, and then it was reversed. I looked at CR, or Criminal Rule 4.2D, which I think is the rule under which you are proceeding. And then finally, I had the benefit of the response to motion for relief from judgment, which was filed by the state. Frankly, that document I was only able to review briefly this morning before we went on the record. But I think the more important documents are the plea document itself, the transcript of the hearing, and frankly, your motion to withdraw the plea. I specifically find that you have failed to establish a manifest injustice in this case, that the colloquy that you and I engaged in at the time of the plea was complete and similar to what I've done many, many times before. And I would have quoted some of the same things that Mr. Sheeran has talked about in his cross-examination of you. I'm not going to belabor that or repeat it, but what I am going to say is that in the colloquy, I specifically went over with you the factual statement of what happened. Of course, there was an in re bar aspect to this with regard to the assault charges, but there was a very specific factual statement that I reviewed with you towards the end of the colloquy, which I'm trying to find now so that I can repeat it. It's found at page 20, lines 10 through 17, where I said to you, there's a factual statement here that supports your plea of guilty to count number 1. So I'm going to read that one out loud and ask you if it's true. Listen carefully. As to count 1, murder in the second degree, in the early morning hours of June 7th, 2015, at my residence, meaning yours, in Pierce County, Washington State, with intent to cause her death, I severely beat Nicole White, a human being, and thereby caused her death. I then ask you, is all of that true? You said at the time of the colloquy, yes, sir, which I've heard before, and then you correct yourself and say, yes, ma'am. We then go on to discuss the assault charges, which were pled to under in re bar, and I'm satisfied there's a complete plea under in re bar. And then most importantly, I go through at the very end and ask you whether your pleas are being given voluntarily, whether anyone forced you, and so forth. And in each case, you answered no. That your plea was voluntary, that no one had forced you, that no promises were made to entice you into a guilty plea. I'm more than satisfied that a manifest injustice is not present in this case, that you are not credible, frankly, in the statements that you've made today and in your motion, and I am denying the motion to withdraw guilty plea. Sentencing remains, I believe, on September 23rd. So that's the next time I will see you for purposes of a sentence.
I'll prepare findings and conclusions for Your Honor. Present the next sentence. separate hearing, I think we can probably do that.
Maybe that would be appropriate. Yeah. Just before then?
Yes,
Okay. Thank you.
thank you.
Here's 2. Mr. Sheeran, 1 and 2, the plea agreement, the document that is lengthy that went along with the statement on plea of guilty, as well as exhibit number 2, would you like those admitted?
We might as well. They're actually probably both already in the court file, but for the purposes of this hearing, they should probably be admitted. They're both referenced.
Any objection?
No, Your Honor.
1 and 2 are admitted, and they will be in the court file. Thank you all. I'm going to step down.
All rise. Court's at recess.
Oh, yeah. Finish the mention.